One of the more common medical errors that result in death or have permanent consequences for the patient is the failure of healthcare providers to properly diagnose a disease or illness. Failed or incorrect diagnosis is not necessarily uncommon, nor is it always actionable as medical malpractice in a suit for damages. Each state sets the rules and law for what constitutes the basis of medical malpractice. Mistakes in medicine will always occur. The issue is whether the healthcare provider failed to exercise a level of competence or process that met acceptable medical standards accepted within the local community. To initiate a lawsuit for medical malpractice, the claim must be supported by an expert, for example, a board-certified physician, who has reviewed all of the medical records and concludes that the actions of the physician who missed the proper diagnosis fell below the community standard for medical care in the community. Beyond the fact of the misread diagnosis, it must be shown that the damage complained of was the result of the failure to properly diagnose and treat. For instance, the defense may be that the outcome ultimately would have been the same for the patient even if the proper diagnosis had been made by the physician at the time. At Carlson and Meissner, for close to 40 years, we have helped individuals in the Tampa Bay area of Florida who have been the subject of medical errors sort through the labyrinth of the law on these very complicated issues.
Carlson, Meissner, Hart, and Hazlett, serving the community since 1971.